Like,
hi, everybody. Good morning. It's Friday, so it must be Friday Facebook Live with Tanya and our expert panel of legal minds, top immigration lawyers in the US. We are going live a little earlier due to demand from people in the Philippines. So I know it's still late. I know it's late in the Philippines, but we wanted to try and go a little earlier to make sure that everybody can watch. Today we have a panel of 3 experts on our on the team who are going to be answering all your legal questions. And I just wanted to, before we start, just give a shout out to the LaFora admin team for giving us this opportunity. For a long time, I've watched as many people in LaFora post their questions to each other, immigration questions. And it's just so amazing to have 3 top legal minds in the US today with us so that you can share your questions directly with them and get accurate information. So I'm going to do a quick introduction. I just want to see that we are, yes, and I'm just looking on my phone, we are live. So we're going to start off with a quick introduction of our panel. And I know that the admin team have posted their bio. So if you want to see more information about the legal team, then please go ahead and check in the LaFora forum. But if you can just bear with me as I read off a little bit information about each of our panel. So the first on our panel is Carl Schusterman. If you want to say hi, that's Carl. Carl has over 40 years of experience in practicing immigration law. He served as a trial attorney for the U.S. Immigration and Naturalization Service from 1976 until 1982, and he's been designated as a certified specialist in immigration and naturalization law by the California State Bar. For more than 10 years, he's been voted as one of the best lawyers in America. As a super lawyer by his colleagues at the bar, Carl was featured by in February 2018 issue of Super Lawyers magazine. He's been named as one of the top 15 corporate immigration lawyers in the US by Human Resources Executive magazine. He has earned the highest rating in legal ability and ethics from the prestigious Martindale-Hubbell Legal Directory. He's been listed in the International Who's Who of Corporate Immigration Lawyers. He has served as an expert witness on temporary visas and green cards for registered nurses before the Senate Immigration Committee in Washington, D.C. So that's a lot of great information and a very impressive bio, Carl. Stepping in for Chris Musello is Maria. Maria Schneider is a partner, and congrats, Maria. I believe that's a new exciting development, a partner with Musello and Conholt. Maria's practice includes both business and family-based immigration. She's a member of the American Immigration Lawyers Association and the Cincinnati Bar Association. She founded and is now vice chair of the CBA Immigration Law Practice Group and serves on the CBA Board of Trustees. She's an adjunct professor. We have a professor in the house at the University of Cincinnati College of Law, where she teaches immigration law. And last but not least is my fellow in San Diego, Jacob Sapachnik. Jacob is the managing attorney of the law offices of Jacob J. Sapachnik and is an active member of the Immigration Lawyers Association. He's invited to lecture on immigration law topics at various conferences in the United States. He provides immigration law support to U.S. immigration clients worldwide. He assists foreign workers to live and work in the U.S. by understanding their situation, goals, and objectives, and obtains the appropriate work and immigration visas. He has been quoted and featured by numerous newspapers, TV outlets worldwide, CNN Money, ESPN, NBC News, ABC, Fox, and the ABA Journal, KPBS, to name a few. He's written articles for various publications in North America, and he graduated from Manchester Metropolitan University School of Law with a Bachelor of Law honors degree. He also attended California Western School of Law in San Diego and obtained his master's degree in international and comparative law. So these are your experts, people. And talking about in the news, before we get started on your questions, this was an exciting week from an immigration perspective, because this week President Trump gave his State of the Union address, and I quote from what he said on that address: "I want people to come into our country in the largest numbers ever, but they have to come in legally." So to the panel, your thoughts on the statement that President Trump made this week?
Well, I'm hoping he really means it, because he has endorsed something called the RAISE Act, which would cut legal immigration in half. But I don't think that bill is going anywhere, because there's just a couple senators from southern states that have proposed it. And even on the GOP side, there's not much support for cutting immigration.
Yeah, I feel the same. I think it's more of a kind of a almost marketing in a way, because there's no genuine effort or push to do any changes, and I think people feel it. We see it from our clients. There's a lot of anxiety and uncertainty, but so I'm not hoping too much from that speech or what's going to happen.
Yeah, I would second everything they said and agree wholeheartedly. I think just the amount of RFEs and other requests from the government we've seen over the past couple of years don't really bear out that they're in support of legal immigration.
Okay, so time will tell. But we have right now Sirison, Chiff is joining us, Chris Contreras, Dane, Maria, Chris Contreras, Janelle, Milana. So lots of people joining us on the live session. And I'm going to get right to our question. So what we've done to the panel is, people ask questions of each other all the time in the forum. So what we have done is people have posted their questions into the forum, and I'm just going to be reading off some of those questions to get your opinion, because really, that's where things can become a little dangerous, where people, who are not lawyers are answering legal questions. So the first question that we have is Pao Abaya, who asked, and that was today, hi Laforans, may I ask how long it does take for a petition to be approved? I just recently sent to my agency the accomplished ETA form that they sent me. Also, I plan to work in another country as soon as I'm finished with my IELTS exam while waiting for my US visa. Can you enlighten me if this is good or not? Thank you. I really appreciate any kind of input that you'd like to share. So I think there are two questions there. One is, how long is a petition going to be approved? Who would like to take that question for Pao? So I'm assuming he's probably born in the
I-140, right? They're talking about the I-140?
Right.
Well, it seems like Pao's just finished the ETA form. So, yeah.
Mm-hmm.
Who would like? Maria, ladies first. Would you like to ask a question?
Everybody jumped at once. So I would say the average processing time for an I-140 is probably somewhere around 6 to 9 months, depending on which service center it's routed to, which is unfortunately not under the control of the employer or the agency. It's just the way that the USCIS processes cases. So depending on which of the two service centers it's sent to, it would probably take between 6 and 9 months. And then the option also is always there to file under premium processing, which would be an added government fee of about $1,400, a little bit more than $1,400. And that would get an answer much faster, probably closer to 2 weeks to a month would be an approval or an answer on the I-140.
Okay.
I totally agree with that. I would say that the $1,410 might be a waste for the employer because the Philippines employment-based third category is backed up about 18 months. So really, in our cases, we file it without premium processing because whether it takes 8 months, 9 months, 10 months, there's about an 18-month wait for you to get to the front of the line if you're from the Philippines.
Right. And also we have to remember that if there's an RFE, that will add more time to the process. And sometimes
yes, absolutely.
Yeah.
And that leads me to another question that I don't, somebody asked as well, and it was somewhere in my list. But if somebody has an RFE and they have paid premium processing, does that mean that the RFE will come back within the 15 days as well? Or is there a time that the RFEs will be answered in?
Right. So the 15 it's actually 15 business days, so it doesn't count Saturday.
Yeah, that's good that we can.
Even though nurses work on Saturday and Sunday. As somebody who used to work for the Immigration Service, the government employees do not work on Saturday and Sunday. So yes, they have to turn around not only the initial petition, but if there's an RFE and you respond to that, they have 15 days to give you an answer.
So it definitely expedites the process. You don't have to wait like a regular filing.
Yeah, exactly. And I suppose it kind of gives you like more control over the process from a time perspective.
Yes.
Yes.
Yeah. So just to go to the second part of the question, which is not really an immigration question, but just your thoughts on that. And this is something that we get from a lot of candidates. Interesting enough, from a Connetics perspective, we have a partner in the UK, and we have a lot of nurses that go to the UK while they're waiting for their green card in the US. But Paul's question was that planning to work in another country when they finish their IELTS exam. Do you think that that's a good idea? What are your thoughts on that?
So you mean that while they're waiting for their immigration here, they're going to work somewhere else, right?
Correct. Yes.
I don't think there's an issue with it. I mean, I think we talked about it before. I mean, they can do whatever they want, and some of these people, they also go and get education somewhere else while they're waiting.
Oh.
I don't think it's going to impact it at all.
Okay.
I think it actually might be a plus for a lot of nurses from the Philippines. I mean, I can tell you, I mean, my wife's from the Philippines, and a lot of the nurses are kind of shy when they come over to the United States. So I probably have a couple dozen hospitals that we represent who go and they recruit from other countries like Australia, UK, Canada, because by that time the nurses are a little more attuned to Western society, and they prefer to get those nurses than to get the nurses straight from the Philippines. So it's probably a plus.
Yeah, that's a good point.
Yeah, absolutely.
Yeah.
And I think anytime you're getting clinical experience, the employer is going to view that as a plus for sure.
Mm-hmm.
And Maria, that's a good point, because the one thing that we've also seen is that the UK can be a very good option for that kind of like stepping stone while you're waiting for your US immigration. But we've had some candidates that have gone to Canada. And if you're going to Canada and that's your end stop, that's of course your choice, and that Canada's a great choice as well. But the thing just to bear in mind, and for many nurses, they don't always realize this until they get to the US, to Canada, is that it's very difficult to get your registration to work as an RN. So if you have a petition pending in the US employers are going to want you to work as a nurse in bedside nursing while you're waiting to keep your skills up. And that's really, really important. So you've got to just be careful if you're going to Canada as an interim measure to make sure that you are able to work as an RN, because in many cases that's not possible, and that can be a major issue for your US immigration. Because I've seen employers, withdraw offers when they see candidates are not working in bedside nursing. So just to mention that. Wow, we're getting a lot of questions from everybody. I've got some of the questions that we pulled up, but I'm going to try and pull up as many questions as we can. Okay, so moving to the next question. Bella Ami, and I think Bella actually asked it twice now. She's asking it today as well. So Bella, we really want to try and get your question answered. She is separated de facto, not legally separated or annulled from her husband. Can she bring her kids, her minors, to the US as immigrants, where she is the principal applicant, where they would be her dependents without written consent from her ex-husband? I don't know if that's an immigration question, or maybe it is. I'm not sure.
So I mean, we see it often in family petitions, where one side is moving, what I always tell them is that if they're both parents have custody and they have rights for the children, one of them definitely need to get consent, because it's going to create, some consular officers would ask that question and would hold a visa until there is clear evidence that kids can leave. So I would definitely try to get legal consent if possible.
Yeah. Because I think otherwise it can become really troubling. Okay, I'm going to read from some of the more recent questions that we're getting, and then I'll go back to my list. The questions are coming fast and furious, everybody. Good. So we got a question from Diane. I hope I'm saying that right. Good day. I want to ask, ideally, how many weeks an agency should file for a petition after passing NCLEX? My agency is telling me they're waiting for the DOLE in approving the wage issue. Who wants to answer that question? Jacob.
Can you repeat the question again?
So the question is from Diane. She wants to know how many weeks an agency should file for a petition after passing the NCLEX. Her agency is telling them they're waiting for the wage approval.
Yeah, I mean, I think it's a good practice to do that, just so we all have no issues later on in the petition. So yeah, I think it's a good practice to do that, to wait for the wage.
Yeah, I mean, what you said at the beginning, the quote from the State of the Union speech, one of the slowest parts of this process is getting a prevailing wage determination. It's now up to about 4 months, and we can't file a petition without getting the prevailing wage. In other words, if the hospital has to pay you the same wage that they pay an American nurse, but the Labor Department determines what that prevailing wage is. So we have to sometimes wait for 4 months. The good part of that, though, is that once we have, maybe 12 nurses in the same position, once we get a prevailing wage for nurse number 1, nurses 2 through 12, we already have the prevailing wage. So there's no 4-month delay at that point.
Yeah.
Yeah. That's a good strategy that we also use in technology cases where we have engineers working for the same company. But it wasn't always the case. Before, we could get the wage in 30 days or less.
Right.
And so now it's a big problem for us. Yeah.
It's got worse. Even in the last year, like 2018, at the beginning of the year, it was kind of taking around 3 months, but now 4 months. And I mean, it's just getting longer and longer.
Yeah. The government shutdown, did affect the amount of time to get a prevailing wage determination.
Yeah.
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 And it's funny. Sometimes I get clients who email me and they don't believe me. It takes 4 months. They think we're just delaying it, or we forgot to file it, or we're doing something. They just don't believe it. It's like this. It's not possible. It's going to take 3-4 months to get a wage determination, right?
Yeah.
Right. Yeah, and it's really important, like Carl said, that you have all those pieces in place before you move ahead.
Yeah.
There's always there's always a client that has a friend. My friend got it in 2 weeks. Well, he got it in 2001.
Right. Yeah, exactly. There's a difference between the first then.
Exactly.
Yeah, I think, this is a question that we get a lot from our side at Connetics, because obviously everybody's anxious to get the cases in and filed as quickly as possible. You want your place in the line, which is perfectly understandable. But I think it's important to be able to understand the actual process and the milestones that a green card goes through, that you've got to go through the posting stage, and then only you file the I-140, and it's that's just the roadmap that we've got to stick to. And one thing that came up actually recently from our side is, you know, some of the hospitals, as you know, we work with hospitals, nursing homes, surgery centers, etc., all over the US. And we had an instance recently of a hospital, one of the newer hospitals that we're working with, that's a union hospital. Can you speak a little bit, or one of you speak a little bit about how the process for a green card is different if it's a union hospital as opposed to one that's not? Crickets? Silence?
I think one of the main differences is, well, two things. One, where the wage might be derived from. So as Carl was saying, you have to file a wage request with the Department of Labor, the U.S. Department of Labor. But if that wage is determined by the union through a collective bargaining agreement, that can impact the process. And then also, instead of posting a notice at the worksite location, you have to notify the union representative about the processing of the case and make sure that they're informed that, that the hospital is hiring these nurses.
So there are a few additional steps. Does it affect the timelines though, Maria?
Yes, it's more just sort of a different route than a sort of traditional hospital where there is no union.
Yeah, but would it make it longer or shorter in the process, or is it pretty much the same?
In my experience, it's pretty much the same, but it obviously depends on how active the union representative is and how quick they are to respond to your requests.
Yeah, because just to share, in this particular case, it was actually quicker. But I think you're right. I think it's just, it depends on the union in that particular situation. Okay, so let's move on to the next questions. We have a lot of people joining us. We have Joanna Liesel, we have Kenneth Galero, Gio, Joy Laurenti, Kim, hold on one second. Okay. Joseph Cabrera asked a question. I wanted to ask if the Filipino nurses will be affected by the temporary or seasonal visa that has been banned or blocked recently.
No, because the seasonal visa that he's talking about is called an H-2B, okay? And that's for people, well, non-nursing jobs, all sorts of different jobs. And there were a couple of countries, including the Philippines, where the administration removed Philippines from the list of people who could participate in the H-2B program because they said too many people were staying in the U.S. after the H-2B ran out. So they removed Philippines from that program. But in all the thousands of nurses that we've immigrated for the last 30 years, we've never used the H-2B. So I don't think nurses should be concerned about that at all.
Right, and H-2B specifically for seasonal work like laborers or hospitality. And again, that's the two problems that we had was that people were staying, but also there was a lot of fraud from agents that were sending them over there, and they tried to stop that. And that's kind of it was a big problem.
So that one we can scratch off our worry list, right?
Yes, right.
We have a lot of worries. We can scratch that one off our worry list.
Yeah.
We have a question from Joan Banda. Can non-Connetics applicants participate in this session? And the answer, Joan, is yes, of course. This is for everybody. We want to share information. We want to provide free guidelines for you from the experts. Okay, so we have another question from Stephanie Castada. Her husband is Syrian. Do they travel ban waiver, and does it affect the filing of her priority date?
Yeah, so that's it's section 202B2 if you want the legal opinion.
Wow.
The Nationality Act.
That's impressive, Carl.
It's called cross-chargeability. So if you're from a country like the Philippines, or it could be China or India, that has a backlog in the EB3 category, but your spouse is from another country which doesn't have a backlog, which is pretty much every other country in the world, you can use your spouse's country of chargeability And from Syria, things are, you said Syria, right?
Yes, her husband is Syrian, so he's Syrian born.
Okay, well, it brings about another problem, but I mean, in general, Syria does not have a backlog, so you could use the country of chargeability being Syria, but the problem it brings up is there's a travel ban right now. So Syrians, I just talked to a Syrian gentleman by Skype yesterday, and we were talking about that. People are banned from getting green cards from Syria. So that could be a big problem. There is a waiver process, but it's very, very small percentage of people are getting waivers, exceptions to that travel ban, less than 2%. There was a Freedom of Information Act request recently, and the government was forced to release their internal guidelines for granting waivers. And I know we posted it on our page. I'm sure other people did that as well. But there's lawsuits going on right now about the waiver process. So, you know, they better sit down with a lawyer and talk about that if, you know, if they're going to try to immigrate somebody from Syria.
Okay. So that actually brings me to another question I want to ask all of you. We had a case recently at Connetics. It was a Canadian nurse who wanted to. She was actually interviewed by a hospital of ours in California, and she's Canadian citizen, but she was born in Syria. Would that be an issue for her to come in on the TN if she was born in one of the countries that were banned, but coming in on the TN visa?
Well, she is now a Canadian citizen, though, right?
Yeah, she's a Canadian citizen.
So she should be fine as long as she's a Canadian citizen and coming from Canada. I haven't ever seen issues with people who are born there. Should be okay.
Maria, Carl, would you agree with that?
Yeah, I agree.
I agree. Mm-hmm.
Yeah. Okay, good. Okay, so we can pass on that information. Okay, so I'm just looking at the question. So Bella Me said, thank you for answering my question. We'll continue to listen to the live session. Thank you, Bella. And make sure everybody to share this with your friends, relatives, colleagues. We really want to get the word out and make sure that everybody gets their questions answered. So I want you to put in the chat box that I have shared this session. Please make sure to share. We want to spread the word. Okay, so moving to the next question, Joanna de Torres. So let me read her question. So she said, back in 2009, she was given a priority date of June 2009. But when it came up to date already, the employer or the hospital was closed. I only passed C2FNS, IELTS, and visa screen, which I'm all valid. I think she's referring to a visa screen there. My question is, what steps do I need to take if I want to take my NCLEX? Is it possible for an employer to recapture my petition? I have to start from scratch. So there's a few questions in that question. And if you want to maybe, let's talk about the third part of the question is it possible for an employer to recapture her petition, or does she need to start from scratch? And then we can move backwards to her other questions.
Yes, it would be possible to recapture. The new employer would just need to file a new I-140 and reference the previous I-140, but she would not lose her priority date or her place in line.
Okay. And we have had some nurses who obviously have got previous priority dates where they don't have a copy of the I-140. So is your suggestion then to try and retrieve it from on the FOIA, Freedom of Information Act?
Yeah, but we do that frequently. I mean, unfortunately, it's taking over 6 months to get the FOIA request back, so it stalls things. But yes, we can get a copy of the notice of approval of the previous I-140 through FOIA. Okay.
So, Joanna, I think I'm just going to answer your questions quickly because they're not on the legal side; it's more on the licensing side. So, if you're asking about your visa screen is valid for 5 years. So, if it's been more than 5 years, which it has in your case, you're going to have to retake that. You're going to have to renew that. And in order to get your your NCLEX. Yes, this is obviously going to be key. Right now, even from the Connetics side, we don't have employers that will even interview without the NCLEX. So if you want more information about applying to write the NCLEX, because obviously there are not all states you can apply to, because some require a social security number, and obviously you don't have that because you don't have your green card yet. There's some great information in the LaFora forum. I know that Jean posted an excellent post recently that you can look at, which tells you which of the states, that's Jean from the admin team, Jean Oliveira, which states to apply to write the NCLEX. Okay, let's move to the next question. We have a question from Faith, who asked, what will happen if you're unable to provide response to a 221G? So maybe we can explain what a 221G is. And the second part of Faith's question is, what if you still have no employer even after you got your green card? How long can you stay in the Philippines? So it seems like Faith has had an issue with her employer. Carl, if you want to take that one.
Well, I mean, it can be a lot of different things. It might be, we've had a lot of people in foreign embassies that are under administrative processing. They're doing background checks, particularly in Muslim countries in the world. If your name is, Ali or Muhammad or something in the name, they'll do a lengthy background check sometimes. And there's not a lot of stuff you can do, but I do have a position right now in Pakistan that they had held. He told me when he first came into the country, 18 months background check. Now we got him an H-1B to work in the U.S., and he's been there 3 months again for a background check. So next week we're going to go to federal court and file something called a petition for a writ of mandamus. And the employer is basically saying, look, I paid the fees. We need this doctor in our area. We want to speed it up. So as soon as we file that, the government will have 60 days to answer us. And in all the mandamus cases we've done over the last few years, within that 60 days, we get a call from the assistant U.S. attorney. They've already talked to immigration or the State Department, and they say, he's going to get the green card in 2 weeks. Will you call off your lawsuit? And we say, yeah. As soon as he gets his H-1B and comes to the U.S., we'll get rid of the lawsuit. So that, unfortunately, that's kind of a, expensive way of going about it. But, I have found from having worked in the immigration service that you get a lot more respect from the examiners if you file these lawsuits, because they know, you're not going to just sit there and shake, because they're doing these things. You're going to take them on. So I recommend that attorneys do that on a regular basis.
That's true.
So you've got to have a good attorney on your side.
And sometimes those 221Gs are different from consulate to consulate, like Carl said. Some of them they want particular documents. Some of them they just do checks, and it's just it's like a black hole. Whenever we get it, it's like it's not a good sign.
Right. Yeah, I've seen some of them resolved in just a few days or weeks, and then other ones, like Carl says, are pending for months and months, and it's hard to know what they're looking for or why there's a holdup.
Yeah.
Right.
Yeah, I mean, we had one with one of our cases. It was a Filipino nurse who I think is actually watching. I can see who's watching. He is in Ireland, and there was an issue with for him, and it was literally resolved. I think it was like 4 or 5 days. I mean, it was really quick. So it just depends on what that is. Okay, we have so many questions coming through now. John Elster asked, why is Nebraska Service Center taking a long time to approve cases compared to Texas Service Center? Is that true? Maria's saying
I don't know if that's true across the board. I mean, like we talked about before, the processing times, I think a lot of things have slowed down recently, that the general processing times are taking much longer.
Yeah. And I think that's the purpose of this session, really, this Facebook Live, is because often there's a lot of misinformation. You know, there's just like people don't really know, and just like a lot of rumor and you know, it's not really correct information. Okay, so I'm trying to pick they're coming fast and furious, everybody, but I'm trying to pick the questions that are going to be applicable, because I think, you know, the importance of the questions also is that sometimes people are shy to ask their questions. So I'm trying to pick the questions that I know that other people might be asking as well, so we can answer the questions that are burning inside their heads, but they are a little shy to ask. Okay, so Faye Santiago asked, hello, is this a fact that filing of the I-140 in the Philippines is done by month in January, April, not in February and March? Filing of the I-140.
She might be talking about H-1B.
Yeah, I'm just thinking Faye's getting confused.
She's talking about exactly the April deadline. Yeah.
Yes, I think Faye's getting confused on the green cards and the H1. Does somebody want, Jacob, do you want to maybe just talk like a 2-minute sum up of the difference between the two?
Yeah, so the H-1B it's a work visa that some nurses can qualify, and if they're new H-1B holders, they need to apply by April 1st of the fiscal year to start working in October, and now is the time to do it. So everybody is like trying to get their petitions filed, but there's a deadline to file it, and it's important to respect the deadline, as opposed to you know, you can file the I-140 at any time, whenever the case is ready.
Yeah, so glad we could clear that up for you, Faye, because that's a big misconception, is the difference between the green card.
Tanya, there's a lot of questions people asking about, and I've seen that as well. People hesitate whether they should file the I-140, or many people are actually engaged and married to U.S. citizens. Should they go with the spousal petition? And I've seen quite a few of those questions. And again, I think, you know, if somebody is married to a U.S. citizen, they might as well just go with the spousal immigration petition. It's, in my mind, a little bit quicker, and of course, guaranteed no IR fees. So if somebody's thinking about it, obviously, you know, the marriage is the way to go.
Okay. So for anyone out there watching, good advice. Okay, Teresa Cabrera asked, can my spouse work already in the US right after we received our immigrant visa? He's my dependent. That's a good question, Teresa. We actually get that quite a lot.
Yes, right. So, you know, when you're a green card holder, so when you're a nurse and you get your green card, your spouse can work, your kids can work, and anyone with a green card can work in the US.
Right.
Right.
Okay. So there you go, Teresa. Your spouse can get a job right away, and I think that will probably help a lot for the family. Oh, Teresa had another question. Candidate who's already holding an immigrant visa still work to our country in the Philippines, or does he need to apply first for dual citizenship? So, Teresa, from what I understand, you're not a citizen yet in the US, so it sounds like you're still a green card holder. But Maria, do you want to maybe take that one?
Yeah, sorry, could you, so she's wanting to know if her...
So she's saying if her dependents who are already holding an immigrant visa can work in the Philippines, or does he need to apply for a dual citizenship? So I think she's also getting a little bit, maybe getting a little bit confused on citizenship and a green card, because I think from the previous question that she's probably a green card holder, not yet a citizen. But if you want to maybe just clarify that one.
So once the immigrant visa is issued at the embassy, there's a time frame listed on the stamp itself. It's usually about 6 months, and you and your dependents have that amount of time to enter the United States. So you have to enter in that 6-month window to sort of activate the green card. Once you cross the U.S. border, then a plastic green card that looks similar to like a credit card or a driver's license will be printed up and sent to the address you listed on your DS-260. If your dependents then return to the Philippines, or if they want to work in that 6-month period, if they have 6 months time and they want to work for another 2 months before they travel to the U.S., as long as they're authorized to work in the Philippines, which I assume they would be as Philippine citizens, that's perfectly fine. And in fact, many times spouses or adult children have jobs or schooling they need to finish up before they move to the U.S. So that would be fine.
Okay. And a follow-up to that, Maria, is do they all need to come through at once during that 6 months with the primary applicant?
No,
or can they
not. But the primary applicant should travel to the U.S. first. But the family members can follow behind so if the nurse wants to come over now in February, maybe her children need to finish school so they can't travel until May. As long as they come before that 6-month expiration date, that's perfectly fine.
That's fine. Okay, good to know. You talk about getting the card. I was born in South Africa, so I'm a proud US citizen now, but I was an immigrant myself, and I know personally how hard this journey is. And I remember when I first came to this country, I think it's almost 20 years ago, when I got my green card, I was surprised it wasn't green. Because you get better. Your whole life you dream about the green card, and then you get it, it's not green.
Right.
But a very exciting moment.
We had a funny thing about that, Tanya. About 20 years ago, there's a male model named Fabio, and I had got him a green card.
Oh, yeah, he's famous, Paul.
Yeah, and we have a picture on our website of me and Fabio right together. But he had a commercial about, I can't believe it's not butter. It was some margarine commercial or something. So actually, we sort of made up a story, but it appeared in papers all over the country. And we're walking out from the green card interview, and supposedly he says, "Carl, I can't believe it's really green." I made that up.
But it is a true thing as an immigrant. You hear about that all your life. I know everybody watching is dreaming of that day when they get their green card. And I can share with you, I was just so surprised. It's actually green. It's a green light, but it's not actually a green card. It's one of my happiest moments 20 years ago is getting the green card. Okay. Let's see. We have a question from Mark Jefferson Belly. And I know Mark. How about waiting for the prevailing wage? So I think we've spoken about that, Mark. I think the panel shared that it takes 4 months for the prevailing wage, and then after that you've got the posting, which, as Carl mentioned, it's oh no, sorry, you're talking about the prevailing wage, the premium processing, but with the posting, it's 10 business days, not just 10, and then it would be the filing of the I-140. Okay, I think we're almost out of time, but let's maybe take 1 or 2 more. Okay, Brian Joseph has an interesting question. Is it okay not to show at your interview date because the employer abandoned the applicant, and will it affect the next petition? So I think Brian's situation where he had an initial petitioner and that petitioner abandoned it. So if he didn't go to the interview date, would that affect the next petition?
Yeah, well, I mean, he should go to the interview or at least write a letter saying that, the application's been abandoned. But, if you show up in person and just explain what the situation is, it shouldn't affect you later on when you have a valid job offer. Sometimes, people in the bureaucracy get confused about, well, why didn't you show up for your interview? I mean, is everything really legitimate? So you should have either maybe a certified letter sent to them or show up in person and explain why you're not going through with the application. Okay.
I'm not sure, though, if Brian means that this has already happened. So if it's already happened and they didn't get your expert legal advice to show up for the interview, can it affect him now? I
think it can raise questions. So even if he didn't show up for a prior interview, he may want to still write a letter to them referencing the date that he didn't show up and explain why he didn't come.
Okay.
It's always good
That's
to be
very
transparent with
important.
them. Yeah.
I'm sorry, Jacob?
No, it's always good to be transparent with them, kind of, you know, so they understand why it happened, because otherwise they will assume the negative.
Okay,
Right.
yeah. Honesty is always the best policy, and keeping everybody informed. Okay, let's see. Oh my goodness, there's so many questions. I don't know who you are. I don't want to.
They just keep coming with those questions.
Okay, we're almost out of time. So we've got one more question. Wilma, and I know Wilma, is asking a question. I'm a Canadian citizen and would like to do consular processing in Canada for a green. Can my husband go on and out of USA to visit while our green card is in process? He has a TD visa. And I know in the fora there are a lot of Filipino nurses that are in Canada, so that will be applicable for quite a lot of people, Wilma. Thank you for asking that question.
Yeah, I don't see
Maria, maybe do you want to take that one?
Oh, go ahead, Jacob.
Sorry.
No, I said I don't see any issues with that. If they have a TD visa, they can go back and forth.
Okay.
If it's illegal,
so even if
passport.
Okay, so even while the green card is in process.
With a TD, yeah, I mean, they have the right to go back and forth as long as they already have it.
Yes, but I think what she's asking is if she's got a green card, that if she's here, so she obviously is here for a while, decides she wants to do a green card. He's on a TD, but now they're going to do a green card. Will there be an issue going in and out at that point? Maria, I think you were going to say.
I think it's fine.
Right. Yeah. And I was just going to say, I think I mean, legally, Jacob's correct. It should be fine. But I think, you know, you could run into a border officer that's confused about their intent. Right. If they've checked consular notification on the I-140, that would indicate that they're planning to return to Canada before the green card's issued. So that's always the best way to go. But, you know, it is subject to the border officers letting them in. But Jacob's absolutely correct. There should be no issue with them traveling. It's just as long as the border officer understands that.
And I would add one more thing. If somebody's doing an adjustment in the U.S. and they're traveling on their TD, that could be a problem.
Yes.
Because then they're already telling them. So an adjustment is definitely, I assume there was a consular thing. And then with those cases, they should be able to leave if needed to attend family needs. They shouldn't be locked in the U.S. But if it's an adjustment, it's a risk, for sure.
Right.
Although
okay, so good advice there, Wilma.
I just wanted to point out one addition to that. If it is an adjustment, they really should be traveling on their advanced parole rather than their TD, and then they wouldn't have a problem. Yeah.
Right. Yeah, there would be probably about a 3 to 4 month blackout travel period while you wait for that advanced parole, and then I agree, and then wait for that travel.
Okay. I'm just watching Jacob adjust his camera. There's sun coming in on both Jacob and I right now. Sunblocks on our faces.
It was a rain. 2 weeks.
Paul and Maria look very comfortable. Jacob and I have got like sun filtering in. Everybody can see this is really live.
No, but people
okay, so
Tanya, people don't get it that we had rain here for the last 2 weeks.
I know, but we can't complain, Jacob, because the Midwest have had Arctic weather, right, Maria? Okay, I'm going to ask one more question, the last question for today. And thank you, everybody, for sending all your questions. I really want to try and get all of your questions answered. So I'm furiously trying to like scroll down and pick out questions that I know other people want to hear about as well. And try and get as many of you your answers as possible. So the last question is for Patrick, from Patrick Bassig, and his question is, his friend is HIV positive, but has passed the NCLEX 3 years ago. Can he still apply for the immigration and can be approved with his condition? So I think that goes to kind of the medicals.
So
Jacob,
as far as HIV, it used to be something that needed a waiver for it, but it's no longer the case. And we've done a lot of waivers for HIV back in the day, but now I don't think that he's going to need a waiver. It's a regular medical, and he'll disclose it, and he'll go through that same process. It's not going to be a reason for them not to be able to immigrate anymore.
Okay. Okay. Maria, Carl, anything to add on that question?
Totally agree.
Yep.
Okay. A panel of lawyers that are in agreement. Wow. It's a good day this Friday. Okay, well, I think, we always say we're going to do this for about 45 minutes over that time. So I really want to thank Maria, Carl, Jacob, for your time. I know how busy you are, and I know how much everybody who's watching really, really appreciates you giving your time and your input and your feedback free of charge, just to make sure that everybody, gets the right information. We're really grateful for that. We're grateful to Lafora for giving us the opportunity. And we look forward to many of you coming through to the US and making your dreams a reality. Please don't forget to share this video with your colleagues, with your friends, and put into the chat box, I'm sharing this video. So please, we want to see I'm sharing this video into the chat box. And this session will be done once a month. So we will be posting the next dates for the session, but keep the questions coming and we will try and get through possible. Thank you, everybody. Thank you. Have a great weekend. Bye-bye.
Thank you. Before the sun gets us.
Yes, exactly.